Let's understand the Draft Forest Act 2019. It is a major change that has been proposed in the Forest Act 1927. Before we move any further, let me quickly give you a background of Forest Act 1927. This act has been India's oldest and still in force legislation to manage the forest, to protect the forest and enforce various controls over the forest. This is the act under which the Forest Department and its personnel manage and protect India's forest. Under this, there are various types of forest-related offences, their penalties, and all these things have been defined. This act has been amended from time to time, including several amendments which are state-specific. How state-specific amendments can be brought in a legislation like this? The answer is simple. After the 42nd Constitutional Amendment, the matters related to forest are now mentioned in the concurrent list. Because they are mentioned under the concurrent list, item number 17, the states are free to amend the legislation in a way that meets their own objectives. So the Forest Act 1927, it is not that it has not been amended and this is for the first time we are going to amend. The fact is that it has been amended so many times, both by the Parliament of India and also by different state assemblies. But for the first time, we have come up with such massive changes in the Forest Act 1927. But at present, these changes have not been legislated. It is a proposed amendment which the government put in the public domain recently, and the government has asked the state governments to look into the proposed amendments and come up with their suggestions, their feedback until June 7th of 2019. After that, it might be legislated. You can easily imagine that Lok Sabha Chunav would have been concluded by that time, and after the Lok Sabha elections, Lok Sabha ke chunav jab ho jate hain, uske baad it will be for the government of the day to take a call whether it needs to be legislated or it does not need to be legislated. But well, the amendments are so wide, so they have such sweeping effect that it is worth studying it for our prelim examination. So now let us deal with some of the basic concept, and we are starting with what is a forest. So what is a forest? The definition has got two parts as of now, and how the forest definition is aimed at getting changed under the proposed amendment, that we will see in a moment's time. But first and foremost, what's a forest? How do we understand forest under the present system? So there are two ways in which we define the forest. The first, the legal definition of a forest. So for legal purposes, all the legal purposes, forest is a piece of land that has been entered into the estate land records under the provisions of Forest Act 1927. It has absolutely nothing to do with the vegetational status. This piece of land may have a dense forest, this piece of land may not have a single tree as of now. But if at any point of time in the past it was entered into the government record as a forest, then it will be treated as forest for all the legal purposes. So this we treat as recorded forest area. So this is the forest area we are talking about. Then we come to forest cover. So forest cover definition is not based on the legal status of the piece of land. When we define forest cover, we go by the definition that has been used by Forest Survey of India since 1987. Why 1987? Because it was in 1987 when Forest Survey of India, which is headquartered in Dehradun, they came up with the very first forest survey, and since then they have been conducting the forest survey once every 2 years. So for the purpose of forest survey, the Forest Survey of India takes any piece of land that is 1 hectare or larger in size and which has at least 10% or more tree canopy density. It will be treated as forest cover. So following this definition, when you come across a piece of land, you will not be calling it forest area, you will be calling it forest cover. Now forest cover definition focuses on the vegetational status of the piece of land, that whether it has vegetation, green vegetation or not. If it has green vegetation dominated by tree, if the density of tree is 10% or more, then only we call it a forest for survey purposes. It does not focus on ownership. So whereas the legal definition focuses on ownership because it has been recorded as forest area under the land revenue record, it is owned by the government, to be more precise, forest department of the government. But when we come to the forest cover, then it has nothing to do with ownership. It can even be a private plantation and still we will be calling it a forest cover. The new amendment, the proposed amendments, they seek to unify the two definitions. How they seek to unify the two definitions, we need to look a little closely on what it proposes. First and foremost, it says that it can be a government land, it can be a private land, or it can be an institutional land. I have highlighted all the keywords in green. So please pay attention to the highlighted words. So it can be government, private and institutional land, and then it can either be recorded or notified in any government record. So if it is recorded as a forest or if it is notified as a forest, then it will be treated as forest. It does not matter who owns this piece of land. Even if a land is being managed by your community as a forest or mangrove, it will be having the status of a forest. Plus, the proposed new definition also says that even in future, if the government, state government or the central government notifies a piece of land as forest, it will be treated as forest. So as of now, we are having two different definitions of forest, but the proposed amendment tells us that there will be a single definition of forest which will encompass all the aspects which is related to defining or describing a forest. So this is one of the major highlights of the proposed amendment, that it gives us a unified definition of what's a forest. Now we are coming to main changes. We are focusing on main changes compared to the previous Forest Act. So the first main change is that it introduces something called Forest Developmental Cess. We will be treating Forest Developmental Cess separately in a moment's time from now, but let us get to understand certain other basic things. So this cess will be collected and it will be put in a special fund. And what the money will be used for? It will be used only for reforestation, forest protection and various ancillary purposes. There will be for no other reason the fund will be utilized. Apart from that, the present amendment also proposes to encourage private forest for nature-based tourism. But we will come back to that as well. So let us first get to understand the cess. The first thing about cess, and this can be important to you for the prelim examination, that who can levy the proposed cess. The thing is, the state government can levy the proposed cess, and the state government can levy it for two purposes. Number one, if you are mining in the forest area. If you are mining in the forest area, then whatever the total value of the mined mineral is there, you have to pay 2% as a cess, and this will be called Forest Development Cess. Second is, if you are using water resources from the forest for various commercial or industrial activities, then the value that has been assessed for that water, so that value's 2% will again be taken as Forest Developmental Cess. And as we had just now understood, that the money coming from this development cess will be deposited in a special fund, and that can be utilized only for reforestation, forest conservation and ancillary purposes. Apart from that, one clarity that we need to have is that Forest Development Cess will be in addition to the existing duty tax which is anyway applicable on utilizing the forest resources. This is especially significant because in our country, one of the major payment that user agencies have to make is called the CAMPA payment. That is, whenever a forest land is diverted for non-forest purposes, under the provisions of Forest Conservation Act 1980, the user agency means the beneficiary agency, will have to pay a specific amount of money to the state government for compensatory afforestation. Here the proposed amendment very clearly says that any tax or any duty which is already applicable, that will continue to apply, and this forest developmental cess will be over and above the existing duties and taxes. So it in no ways affects CAMPA. Again, thinking of the prelim, it can be asked as a statement that the proposed amendment in the Forest Act 1927 abolishes the concept of CAMPA and brings in its place a much more holistic forest developmental cess. The answer is, this is not a correct statement. CAMPA or any existing duty will already be in place, which are already in place, will continue to be there, but this will be over and above, and this will be augmenting the financial resources in the hand of Forest Department for conservation as well as management. Now, main changes, we are continuing with them. So it brings a new category of forest that we call production forest. So until now, we didn't have the concept of production forest, but now we are having a concept of production forest. What's a production forest? Name itself gives you a clue that it will be a forest which will be meant to produce economically or commercially important forest resources. For example, timber, pulp, pulpwood, firewood, non-timber forest produce, medicinal plant, so on. So in a specific parts of the country, the government can give authorization to raise a production forest, and the production forest will be aimed at yielding the forest resources of commercial value. Until now, this category of forest has not existed in our country. Next thing is that till now, there are three categories of forest which have existed. First one that you see on your screen is reserve forest. Reserve forest, under the provisions of 1927 Indian Forest Act, is a forest where every activity is considered to be prohibited except those which are explicitly permitted. In other words, there might be one or two activities which are permitted. So apart from that one or two permitted activity, every other activity will be deemed as non-permitted, deemed as prohibited. This is a forest where the government agencies have maximum control over the forest resources and the forest land. Next comes protected forest. In protected forest, the government agency does have an overarching regulation, but here the control is a little lax compared to the reserve forest. And that comes directly from the definition. When you talk of what is protected forest, then here every activity is deemed permitted except those which are explicitly prohibited. So here the activities which are not meant to be carried out in the forest area are clearly prohibited, except that every other activity will be deemed as permitted activity. So that is protected forest. And thirdly, there will be village forest. Village forest will be a forest in or around a village where a good amount of control will be available to village community, but the control will not be extending to timber rights. But village community will have some control over minor forest produce, which are non-timber produce. So until now we have had three categories of forest. Under the present amendment, a fourth category has also been proposed. Then we come to private forest. In the beginning, if you recall, I had spoken about private forest, which are supposed to be encouraged under the proposed amendment. So let us get one thing very, very clearly. Again, it can be significant for your prelim, that even today in India, we have got private forest. It's not that private forest is a new concept that this proposed amendment is bringing. In parts of northeastern India, especially in Nagaland, there are vast swathes of private forests. But it is for the first time that the government of India is trying to encourage the private forest. But how? It says that the state government can notify private forest if the owner himself comes up with a request that please notify this land for management purposes as private forest. Once it is declared as private forest, the first thing that happens that the management is carried out by the forest department. But apart from that, the purpose will be primarily conservation and protecting the water catchment. But there can be tourism activity which can also be allowed. And in this tourism activity, it is important that local people will be given different types of work so that it also serves the purpose of employment generation. So that is private forest. Point to remember, it already exists, but for the first time we are trying to encourage it. A state government can notify it, but the request must come from the owner. Once notified, management will be done by the forest department. The primary purpose will be conservation and protecting the water catchment. Tourism may also be allowed, nature-based tourism, but for this, the village communities' engagement will be necessary. Now we come to main changes which are continuing. There will be higher immunity to the officers if they use firearm in the forest area. Until now, most of the forest officials do not have a permission to carry or use firearm in the forest area. For the first time, to protect the forest from timber and poaching mafia, this control, this regulation or restriction over the forest official is proposed to be diluted. There are new categories of offences which have been defined, and there are enhanced penalty and jail term for the offenders. So let us deal with certain good aspects of the proposed changes. First and foremost, when we think of the production forest, it will be meeting national developmental aspiration. Understand that India is a net importer of timber. We are unable to meet all our timber requirement from our domestic resources. So for the first time, it is likely to lead to a situation where at least for timber, we can be self-sufficient. Plus, there are certain international commitments also, which will be catered if we bring the needed changes in the law. The next thing, it will promote forest-based industry, and some of you might be thinking that promoting forest-based industry may not be a good idea because it will deplete the forest resources. But understand that wood is always more sustainable source compared to plastic. Plastic disposal is a serious problem, and the substitution of wood by plastic is never an ecologically sound idea. So it will be promoting forest-based industry, it will be contributing to national GDP, and it will certainly be increasing the employment opportunity. The next will be, if there is cess coming to the forest department, it will be creating additional financial resources at the disposal of forest department, which can be invested in forest conservation, forest management. Next one is that it is a welcome move to engage the private landowners and come up with the request that let us notify it as a private forest, because it will increase India's managed forest cover. Next is, we are still continuing with good aspects. So there is tourism involving local community. So it is aimed at employment generation, and enhanced punishment. Now I am coming in some detail. So enhanced punishment is certainly going to be a serious deterrent. If you think of today's punishment, it is ridiculously low. So for forest related offences at present, an offender can be jailed for a period of just 1 month, and the fine can be 500 rupee or both. Do you think it is going to be ever a deterrent for mafia elements interested in timber and wildlife? Answer is no. So now we are having enhanced punishment. So now under the new proposal, imprisonment can range from 1 month to 7 years or even more depending on the offense. Plus the fine amount will be between 5,000 to 5 lakh rupee. So it is hoped that it will be a good deterrent for the chronic offenders. There are still some cause of concern. The first cause of concern is that when you apply a cess for utilizing the forest resources, in a way you are monetizing forest destruction. That more you destruct the forest resource, the more cess you will be paying and the more money will be coming to the government. But how long it will go on? It lasts as long as your forests are lasting. Once your forests are gone, there is no cess. So do not legitimize, do not monetize the destruction of forest. That's the first point. Second, it encourages private sector investment in forest. The critics say that private sector can never be serious about conservation. They always will be profit driven, and if they are profit driven, it will actually be encouraging the practices like production forestry, monoculture, and these are actually not very sustainable ideas. Some more cause of concern, and this one is serious, that it has a direct conflict with Forest Rights Act 2006. Forest Rights Act seeks to give forest land ownership to the native forest dependent communities. It includes Adivasis, at the same time other non-Adivasi forest, traditional forest dwellers. But under the proposed amendment, it has been said that if it is found that Forest Right Act implementation is hampering the conservation effort, then the state government will commute such rights, means it will withdraw such rights by paying monetary compensation or by paying land compensation, or for that matter by using any other method which the state government deems fit. So critics have to say, social sector activists have to say, rights activists have to say that it is certainly an idea which is directly contradicting with the implementation, with the ethos of Forest Rights Act. And this is something which the government must seriously look into. Now, to conclude, there is a graphic that summarizes all the points. It has been taken from the Times of India, and let us quickly run through the points. First is the forest officers get more immunity to use firearms. Second, no prosecution sanction will be given until there is an inquiry by an executive magistrate. Next, there will be more indemnity given to the forest officials, plus a forest official not below the rank of assistant conservator of forest can search any place where he has a reason to believe that a forest related offense has been caused or result of a forest related offense is stored at a particular place. Last but not the least, any person, forest officer, cannot withdraw Forest Offences Act registered under this act. It means that this part of it cannot be amended by the states. So these are the main points, and if you notice, this graphic gives us certain additional point which we had not discussed until now. So for your prelim purpose, as well as to lay a foundation for your main examination, knowing this much will be enough. If you are looking at mains oriented coverage, then of course later after the prelim examination we will be discussing a lot of pros and cons of the proposed amendment, and by that time it will also be pretty clear what the next government's thinking is with respect to the proposed amendment. So that is on this topic. So goodbye and good luck.